Hey, Kevin.
Hello, Rebecca.
Can you believe what we're doing?
It's Friday, so it must mean it's a Readathon.
Yeah, so I have some items to tell you about, and then a really interesting hearing that occurred this morning that I just watched.
Okay.
So first for the items, one is that Karen Read's appeal before the First Circuit Federal Court has been denied.
Okay.
That news broke as we were taping our Readathon yesterday, and I put a note in the show notes, but I just wanted to memorialize it for the purposes of this podcast.
Okay.
Second item, and I haven't read the order yet. Or she usually doesn't write particular orders. She usually just writes denied or approved in the bottom of things. But I've seen news that the motion to suppress the manner of death filed by the Commonwealth has in fact been denied.
Okay.
It's being touted as this huge victory for the defense. And I'm like, no, it's just standard.
Yes. Well, it avoids a huge setback because remember, the manner of death is usually either accidental or undetermined, or homicide, and this is a homicide trial. And if the manner of death, according to the medical examiner, that she put down undetermined, the jury needs to know that.
You think? Commonwealth didn't want the jury to know that. Commonwealth
didn't want because evidence would be confusing.
Because it's exculpatory.
It's exculpatory, right? It certainly gives jurors something to think about. So well. Good catch.
Yeah. So there's an interesting motion that was filed by the Commonwealth. I've read both the full motion and the full defense response. It is a sweeping reciprocal discovery motion with regard to ARCA.
Okay.
It includes some weird language that people are interpreting as the federal investigation might not be over.
Yeah.
I don't think that's a great interpretation of it, but it could be. Yeah. So I'm not going to dwell on that. But their motion said, because of things that Yannetti said in court, by the way, I'm paraphrasing, it didn't say it exactly. Yeah. Because of things Yannetti said in court, we don't believe the defense has complied with their full discovery with regard to ARCA. So therefore, we want the following things. And it's this long ass list of things, including every notes, emails, whatever, correspondence with ARCA, correspondence with the U.S. attorney, correspondence between the U.S. attorney and ARCA. It's like this long list of things, receipts, contracts, et cetera, et cetera, et cetera.
They want it by Tuesday.
The defense response under every item was, we've given this to you. We've given this to you. You have this. We've given this to you. We've given this to you. We've given this to you. You have this. We've given this to you.
It sounds like when I complain about you giving me something and you're like, I gave you that. I told you that already.
Right. Or
you
vice versa.
Yes, or vice versa. Check the drawer.
Exactly.
I did. Check it again.
Exactly. But essentially, what Brennan is clearly trying to do is plant more doubt around these witnesses with the court.
Oh, right.
He's trying to plant more doubt because he knows for Cannoni, these witnesses are a hot button issue. And any opportunity he has to throw them some shade, he is going to take for that reason.
Right. Okay.
So let me just read you the language people I think are misinterpreting real quick.
All right.
He says, additionally, on March 20th, it was disclosed to the Commonwealth for the first time in an open court that Attorney Yannetti had received a federal subpoena from the United States Attorney's Office to produce his entire case file. On March 25th, 2025, the defense further disclosed for the first time that the subpoenas Yannetti was referring to was, quote, an ongoing federal subpoena. On March 25th, the Commonwealth was informed the discovery produced to the defense was in turn being provided to the U.S. Attorney's Office in an ongoing manner and included the entirety of the Commonwealth's discovery referenced in Notices of Discovery 1 through 57. Some people are interpreting that as the defense is still sending stuff to the feds. I didn't hear Yannetti say anything other than he received a subpoena for his whole case file, during the last trial.
Yeah.
And any mentions to ongoing, I didn't hear those. Maybe I missed them. Could be Brennan just purposely misinterpreting something to get something he wants.
Right.
Which, by the way, put a pin in that. It comes up again later.
Okay.
It could be that, implying that they are still cooperating or something with the feds. But the reason I doubt this is because I watched the whole thing and that would have stuck out to me.
Yeah. Yeah. And I think one thing that people need to remember here is that sort of the idea that the feds may have closed their investigation into this case because they found nothing is one possibility. But also we need to know that writ large, the new U.S. Department of Justice has been ordered to end investigations, public corruption investigations into police departments.
And civil rights investigations.
And most police department investigations are around civil rights, right?
So if Trump had been elected before the arrest in the Sandra Birchmore case, that investigation would have ended.
Yeah, very, very likely so. And so it's hard to, you can read either thing into it, that either they might have just closed it up because there was nothing left to do, or they might have been ordered to close it up as all these other police corruption investigations across the country have been ordered to do.
Right.
And if that is the case, that does not exonerate the Massachusetts State Police or the county district attorney.
Right. There's a third possibility that I just want to throw out there that I haven't heard anything about. I'm not saying this happened, but it's speculative possibility. The investigation could have been closed and a new one could have been opened that uses materials from the first one.
This is true. This is also true.
Absolutely a possibility.
If they've got the go-ahead
under
to do
a
that.
different umbrella of categories, perhaps. You know what I mean?
Yeah.
Okay, so now I want to talk about the hearing that I just watched. It was so interesting. This is once again, this is Judge Sititsky, Judge S. I'll just call him Judge S. Look at this name. Sititsky. Anyway.
Sisitsky.
Yeah, say it again. Judge Sisitsky. Okay.
Sisitsky, yeah.
This is Judge Sisitsky, who I misidentified as Judge Doolin the last time I talked about him. And that was because in that case, as in this hearing, it was filed to be seen to be with Judge Doolin, but both times we got Sisitsky. Right. Okay, let's call him Judge S. Okay, from now
Judge
on,
S.
for the purposes of my lack of stuttering.
What's his first name?
I don't know.
Can't we? If we have Auntie Bev,
Uncle S. Okay, so what this was about was something we talked about briefly in the last Readathon. So I'm now going to explain it more thoroughly because this is what this hearing was about. Judge S. previously ordered in response to Hank Brennan's request. This was the hearing where Karen Read and her team busted in. He issued this very narrow scope of an order, which said the Cosgrove prosecution, which is the prosecution of Aidan Kearney, and the Read prosecution, the Cosgrove prosecution can share with Hank Brennan communications on Aidan Kearney's phones between himself and Karen Read regarding illegal activity, witness intimidation, etc. That's what the order said.
Right.
Communications have to be that.
Not everything else.
No.
Not other. Okay, right. Very limited scope. Okay.
Keep in mind, one thing to know, and I don't think we've talked about this before, is that allegedly Michael Morrissey, and I say allegedly only because to take things at face value from this office is difficult for me. Allegedly, Morrissey has conflicted these two cases. So the two prosecutors...
You mean conflated the two cases?
Conflicted.
Conflicted the
So
two
the
cases.
two prosecutors are not allowed to discuss them with each other.
Okay.
Which is why Brennan had to file a request to ask for these materials, okay?
Okay.
So there was...
my boss says I can't have it, but whatever, yeah.
There was some... quote, misunderstanding of the judge's ruling by Cosgrove and Brennan, which is the reason we had this hearing today. There was one issue around that, and the second issue was Aidan Kearney's team wants the prosecution to specifically be barred from sharing prosecutorial materials with three people who tweet about them constantly and always say, we got this in advance, and from the public at large, anybody who doesn't work there. And Bradel said, and I'm only saying this first because it was over pretty quickly, Bradel said, we know this is already a rule, but they are doing it and we have proof. And Judge S. said, actually, I read this whole thing and I read the attachments. I'm like, oh my God, you did? And he said, I can't rule on this now, but I'll take it under advisement. What he was talking about today was this disclosure of stuff from Aidan Kearney's phone to Karen Read's prosecutor, Hank Brennan. Okay. What happened was, after he issued this limited order, the Cosgrove, the Aidan Kearney prosecutor, created a thumb drive that was intended to be given to Brennan.
Okay.
The thumb drive by the judge's order has been sealed because of this pending hearing, and no one has seen the contents of it yet except for Cosgrove and his team, right?
Okay.
What this hearing was about was that Hank Brennan, he interpreted the ruling to mean he should also be able to see any communications with Aidan Kearney that included Karen Read's legal team. Okay?
Okay.
And the judge was real mad about this. He basically said, I don't understand why you did this, because in court you acknowledged this would be privileged and that you wouldn't look at this. And Brennan said, yeah, that was my misunderstanding, blah,
this
blah,
guy
blah,
passed
blah,
the
blah.
LSATs, right?
He did. He did. He says there's no joint defense. The reason he misinterpreted it is because there is no joint defense between Aidan Kearney and Karen Read. So he believes there's no privilege between Aidan Kearney and Karen Read's lawyers. The judge was so mad, he just cut him off. He's like, I'm going to stop you right there. Okay?
For information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there, because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you.
So he turns then to Aidan Kearney's attorney, who's on Zoom, as is Karen Read and her attorneys. You know, what do you say about this? Do you think that there's privilege between Aidan Kearney and Karen Read's attorneys? And he goes, no, we don't assert such a privilege, but I have said we've been helping each other and talking to each other. There's no formal agreement. And then he added, I don't even know why we were talking about this, because your order was so clear. It should only include communications between Karen Read and Aidan Kearney regarding witness intimidation. They say in their motion that's what they want, and they say it's to prove consciousness of guilt. So then the judge interrupts Bradel and says, listen.
Who's Bradel?
Bradel is Aidan Kearney's attorney.
Okay, sure.
And he says, you know, in the age of group texts, we certainly have the likelihood that some of the communications between Karen Read and Aidan Kearney included one or more of her lawyers, you, etc. And then Bradel came back and said, yeah, but the whole reason of this is consciousness of guilt, you know, and we have the extractions. There is nothing that falls within the definition of your order. Nothing. So there should be no thumb drive. There should be nothing. This is a can of worms you didn't open, was one of the quotes. So he said the thumb drive cannot comply with your order because we know there is nothing that falls inside the category that you laid out in your order. Okay?
Okay.
He said it's inappropriate that Cosgrove is trying to jump over your order. They allegedly have this conflict of interest thing, and he's trying to jump over that. So then he turns to Cosgrove, who's the lead prosecutor against Aidan Kearney. Actually, I think he might be a special one because the lead one, Mello, got really sick and had to sort of drop off the case. Anyway, so Cosgrove is now the prosecutor. And he said, here's my interpretation of why this is not privileged, Cosgrove said. The actions of the attorneys for Karen Read are the actions of Karen Read. And if one sees these texts between Karen Read and her attorneys and Aidan Kearney, one sees a pattern of feeding information to Aidan Kearney, which implies consciousness of guilt, especially around witness intimidation, is what he's saying, right? So the judge, kind of ended him. He's like, enough. He says, I am ruling that the production can only include communications between Aidan Kearney and Karen Read. And he's basically like, we've covered this. I expect you to comply with it. So then the thumb drive.
So basically, if my understanding is correct, and in a nutshell, what they've done is they are trying to interpret the ruling to include not just Turtleboy Karen Read communication, but also any of Karen Read's attorneys with Turtleboy Aidan Kearney, because they are arguing, anything that they do is what Karen does.
Right. They said the attorneys are Karen Read.
They are Karen Read. Okay.
That's what he says.
That seems pretty novel interpretation.
Right. It is a novel interpretation for sure. And, and then Brennan was very defensive. He wanted to get up and just make a final statement. And he said, I just want to say that the gag order placed on the defense attorneys and the attorneys in the Karen Read case was at my request, because I perceive there to be risks here of leaking. That was me.
Yeah.
That was me who did that. And and then he said, the whole reason I filed this motion is because I'm an ethical person. And any leaks, and by the way, Bradel's attorney has some of this in his other motion, and which I'll talk about in a sec. Any leaks from my office to anybody are prohibited, and I would not allow them. Okay?
Okay, you're on the record.
Yes. So the second motion that they talked about today, which the judge did not decide on, but is going to take under advisement, is this protective order request from Attorney Bradel for Aidan Kearney around any communications to 3 specific individuals and anyone in the public about materials in Aidan Kearney's prosecution. Okay?
Right. That would be leaked from the prosecutor.
This would be people like Jen Coffendander, who's on Twitter, etc. And they have what they say is proof. And I've seen it over and over and over again. Coffendander, Yellow Cottage Tales dude, whatever. They say, I just received this. You're going to be hearing about this. And then they say something which has not been made public yet. This has happened again and again and again and again. So they made some attachments that show that. And then they also had Aidan Kearney write this affidavit saying, that he has been the subject of communications from people saying, well, I have this material about you. And he's shown them Kate Peter communications, etc. So that's essentially it. He did ask Yannetti or Little if they had anything to add with regard to Aidan Kearney's motion about leaks. And he said, I don't, but it is concerning to me that Attorney Cosgrove revealed in a public motion communications between us, Karen's legal team, and Aidan Kearney when it was specifically prohibited. He said he cherry-picked the communications, and he specifically did not include the part which was us warning Kearney around things like how to do protests, his behavior generally. Like what he was basically saying is we've told Kearney to not do bad things, and that part was eliminated. And the judge was like, what motion was this? And he said, it wasn't in front of you. It was in Kearney's case, which was a separate docket number from this particular docket number. And the judge was like, okay. So, he's like, I'm taking all this under advisement. And that's when Brennan made his for the record statement. I'm a good guy. This was all my idea. So that was the hearing that happened today. It was so interesting to hear a regular judge, what I'm going to call a regular judge, because he was prepared. He was angry at the violation of his specific orders. He remembered his own specific order.
Right. He's an assertive judge, which is fine. I mean, you want someone to not only be the referee, but also someone that manages the courtroom, moves things along, gives the impression
interrupts people when they're rambling,
gives them the impression that they're in charge and they're running a courtroom, and not letting everybody else, not being so passive and letting everybody else take over. Yeah.
It was really interesting, and it was interesting to see this pattern emerge in this other courtroom that we have seen emerging in the Canoni courtroom again and again and again, where an order is issued and then Hank stretches the interpretation of the order or ignores the order and does something else and then says, no, that's not what that. And then Canoni believes him, gives him the benefit of the doubt, but never the defense. So it was interesting to see a break in that pattern of him using these same tactics in front of another judge and another judge being like, how the hell did you come to that conclusion? Because my order specifically said X, and that does not include Y.
Yeah.
So anyway, that's why I wanted to tell you about it. I found it interesting, and I'm going to post a link to the video of that hearing in the show notes for this so folks can watch it for themselves. It's very short. It's only it's less, maybe 20 minutes long, maybe less.
And we're 2 business days away from jury selection?
We're 2 business days away from the convening of the impanelment of the Karen Read juror, the official start of the Karen Read trial. That's how it starts, is with jury impanelment. That is Tuesday, April 1st.
All right.
Listen, I keep saying I don't think we're going to be back before then, and I keep being wrong, so we'll see.
All right.
Maybe something else will happen today, and you'll be at baseball, and I'll have to come here but down by myself and do a readathon. Who knows?
I don't know.
All right, but that's it for this one. Thanks, Kevin.
You're welcome.
Partners in Crime Media.